Our instructor for this video is Kevin Burke. This training is not intended to be a substitute for the advice of your broker, nor that of your attorney. Let's get started.
We are going to be talking about the new forms that are out. Now, some of you might have experienced in the last 36 hours that we were, zip forms was down. As you know, I'm on the Lone Wolf at the Customer Advisory Board, and I've been talking with them at the highest level as far as what's going on. They still don't know what caused it, but it is up and running again. So if you have any issues with it, would you send me an email and let me know that you're having issues with it? Currently, like I said, they fixed it supposedly, but if you're still having problems, please let me know. I mean, it's important to us that the program is working for you, okay? So that being said, the reason I'm bringing that up is because we will be publishing the new forms and we will be updating the existing forms on the 21st of December. All right. So here's my caveat to you, because listen, I don't want anybody, I like going to court. I don't want you there. I mean, it's just not a pleasant experience. It's very stressful. And I hear people all the time just saying, I don't care. I got E&O insurance. No, I'm sorry. You might have E&O insurance that may not cover you, but you also have to prepare and gather information and put up a defense. And so you don't want to do that. I mean, depositions are very intimidating. So let's talk about our forms. On December the 21st, we are going to load these forms into zip forms for you. Now, we are still working on these forms, okay? So I'm going to show you the red line version of these forms as of today, okay? So it's going to say across the form, draft. That doesn't mean it's chilly in here, okay? Draft means that it's kind of what we think we're going to be doing, right? I mean, I'm looking at the home fire hardening disclosure and advisory, and I guarantee you it's not going to look the way it looks today. I'm going to show you the principles behind it, but the idea is that it's going to be a different form, okay? And so because there's some legal issues, we've, that you have the San Diego Association of Realtors has one of the premier risk management committees in the country. A lot of the stuff, in fact, our local area disclosure is used as a model across the country and in some parts of Canada for how you should be doing things. So it's our local form that we have created, often imitated, never duplicated, that kind of thing. But really a good form. So when I'm telling you the things I'm telling you today, I'm telling you because I'm telling you for your own protection. Do not use a draft form until we release it, because we're not done here, okay? And then, so what we do when we do release the forms, they will be new. We will update the forms in your library in zip form. So that means in your library where all the forms are, we are going to update that, okay? So we will fix that for you, and we will put new forms in there that aren't there currently, like the HHDA is not there currently. Excuse me. Sorry about that. I'm sorry about that. But we will load those into your library. Okay. Now, if you have a template that you have created in the template section of zip forms, we will update the forms in there as well. So for example, we're going to talk about the COP form. So in your library of zip forms, the COP form in the library will be updated at the appropriate time. Don't use it until then, okay? And then if you have a template under the template section of zip forms, and I teach that class too, I want you to know how to create templates, because I think, our business is a rote business. We do the same thing again and again. We will update your template. Now, in the template, we will update a form that you have, but we won't add new forms into your template. And I'm differentiating that on purpose, because a lot of times we think a template is something that we are using again and again under the transaction side of things. And I'm going to tell you, we're not going to touch a transaction you have in progress. So, I've got one of our brokers came, sent me a thing, and I'm looking at it, I'm going, God, we haven't used that form for like 8 years. And the broker said, well, you know, I keep copying a transaction again and again and again. And so if you're copying transactions because you thought you did something really cool, my advice would be to save it as a template in zip forms so that now we will update the forms for you. Does that make sense? Okay. But what that person was doing was copying a transaction. If you're copying a transaction and you're copying one that you thought was really cool that you did before we changed the forms, you're not going to have the current forms in there. And I'm going to tell you, when we talk about this FHDA, I mean, there are some serious hot buttons in there that I want you to know about, and I would be definitely using this. This is on fire across the country, no pun intended, across the country right now. I'm on the NAR's Risk Management Committee and chair of their West Coast Advisory Group, and I'm going to tell you something. It's scary. It's a lot of crazy stuff going on. Okay. And so, you know, business as you knew it is changing. Guess what? That's called job security. So you have to know the forms. So let's launch into it here. And I've put them in the order that I think are the most important. And I'm going to start us off. We're going to talk first. We're going to talk about that HHDA. So as you see here, new form. So it's not in your library right now. Here's my FHDA new form. It is not in your library right now. Okay. So I want to make sure that you're using these forms when they come out, but not before we get there. Okay. And I know I'm sounding like a broken record, but it's pretty important. Okay. Then down here where I'm talking, see right here, it says okay to use prior revision. Down here, it says, is it okay to use the current COP, C.A.R, NBP, RCJC, and Sfls? And the answer is no, it is not okay. When we update it, you need to update it as well. Okay. All right. So again, if you have a transaction in progress, keep using what you're using. Check with your broker for sure. Keep using what you're using, but you do not want to use after the publish. You don't want to be using the older versions of the forms. Okay. And remember, when we create our forms, we do it in response to legislation and litigation. We call that the two L's, right? Legislation and litigation. And so that's why we update our forms. That's why we create new forms. You know, when I started in real estate, we had a one-page purchase agreement. It's very different today. I started a presentation the other day where I told them, I said, you know, we've decided that real estate's gotten too complicated. We're going to go back to the one-page form. And then I showed them the one-page form from 1971, right? And I was using that form when I got my license. When did I get it? 77, something like that. And so, you know, I'm going to tell you, they ain't going back to that. We have all of this because we create these to protect you. Okay. And so, you know, you're our client. We want to make sure that you're okay. And so as a result, we do these things. Today, we've got 250 forms in the library. All right. So please make sure that, you know, if you don't know what form to use, you can always get a hold of me. Or check with your broker first, right? Always with your broker first, and then you can always get a hold of me, and I'll let you know if there's a form. Your zip forms program is going to start changing. Start looking different to you in the beginning of the year because that old forms advisor that nobody seems to be using, we're going to start the zip forms program is going to start looking like that. It's going to start asking you a series of questions, you know, and you can go in and play with forms advisor right now. You can't break anything. We've been using it for a decade. You can go in there and you'll see it asks you questions about your transaction. It'll tell you what forms to use, and then Forms Tutor will tell you how to fill them out. So we've already done all this. It's very, you know, the behind the scenes is very complicated stuff to make it easy for you. Okay, that's all. That's our whole point. All right. So let's talk about my home fire hardening disclosure advisory. And again, satisfies the disclosure requirements that start in January and July of 21. So remember, our forms update in response to legislation and litigation. Legislation usually takes effect either on July 1 or on January 1. So we always come out with a form right before the law actually takes effect. And that's what's happening here. Satisfies the disclosure requirements that are not law today. They're not law until January 21, okay? Concerning the home hardening and defensible space, respectively, should be used if property is located in a very high fire hazard severity zone. So the issue that's going around with the lawyers on your risk management committee here at the San Diego Association is that, you know, now we're in the position of having to give legal advice to our client as to whether or not their property is in one of these zones. I have to agree with Jackie Oliver, who I just think is just an amazing lawyer, and I have to agree with her that the natural hazard disclosure companies are probably going to start using this in their programs, in their forms, and that'll be there again to protect us. But until that happens, then you might want to be using one that is current, a natural hazard disclosure company that is current, as well as using the current form in your transaction. It's just going to be a judgment call on your part whether or not the property is fine. And frankly, I think this is one of those forms that I say that I think, wow, it took us long enough to get around to this, and I'm surprised that it did, but here we are today. Okay, so let's take a look at my form. It's my HHDA. It's my home fire hardening disclosure and advisory. Okay, and thank you to the association. They've given me 15 extra minutes today to talk to you about these forms. So we have a little bit of time. And again, if you have a question, type it in, Q&A. Go ahead and type it in, and I'm happy to answer it in any way that I can. Okay, so don't be shy. All right, so see right here, revision date 12/20. Well, yeah, it's a brand new form. Okay, all right, so here's my recitals up here at the top. It's a disclosure and addendum to the purchase agreement. So at the time you write your offer, or if you receive an offer that doesn't have it, and you as the listing agent are aware, or you as the seller's agent are aware that it applies, then you're going to want to use this form. Okay, all right, and just add it to your contract. Okay, so dated, all this is called the recitals up here at the top. This is the linking part of the agreement, that the header that links all of your forms to the purchase agreement, to the listing agreement, things like that. So it's part of the requirement of linking it to the transaction. So home fire hardening prerequisites. It talks about what the law says. And so it's for property. Note, it is for property that was built before January of 2010. So property built before that. Okay. So property built after that, you don't have to use it. Isn't that interesting? Okay. Where to locate Joan? Hi, Joan. Question. I'm sorry. Maria has a question. How do I know if the property is located on a high fire zone? Yes, Maria. Thank you. Great question. Okay. Now here's why. You don't, right? And I don't want you going and looking it up. Just like I tell you, don't go pulling permits, right? I mean, it's just, we get into a lot of trouble. Remember that if the property is located in the zone and it's the seller's requirement to make the disclosure, if the property is in the zone and the seller doesn't tell the buyer that it is in the zone, remember it's California Civil Code 1103.7, which is your natural hazard disclosure law. And so the problem is in litigation, it tends to be that the award is the price of the property, because if the property was in the zone and the seller didn't tell the buyer that it was in the zone, then that means that the only way to fix the situation is to buy the house back, right? You can't move the property out of the zone. So it's been the cost of the home. Okay. So how do you find out, Maria? The way you find out is you get that NHD order up front. All right. So my how to create a winning listing presentation. I talk about that at length. Get my disclosures done up front. Get my TDS, which is 1102.3. Get my NHD, which is 1103.7. Get all those statutory disclosures done at the time of the listing appointment, right? And so if you got that, now by ordering that property ID or whatever you've ordered for natural hazard disclosure, it will tell you it'll tell the seller whether or not the property is located in that zone. This is so important that we no longer have the form in the library. We took the form out of the library because we want people ordering from a third party that has, by the way, insurance to cover a mistake, whereas the seller and you don't have insurance to do that. Okay, so get that ordered early in the transaction. If most of them, I can't speak for all of them, but most of the companies, if you don't use their program, you don't get charged for it. They just essentially charge you, based on, do you want protection for the liability? Okay. Maria, I hope I answered the question. Oh, thank you. Okay, thank you, Maria. Thanks for letting me know. It's always very kind when you let me know I answered the question, because I keep on rambling, as we say. Joan, why wouldn't we use this for new construction if we think the property is in a very high fire severity zone? So the answer is that, remember, in new construction, you're going to have what we call the subdivision report, and that information is supposed to be included in the subdivision report. That's part of the requirement for the developers when they're building property, that they have that also have that natural hazard information collected as well. Great question. I would think the NHD or the seller would know for any properties built 2010 and later. You would think, right? But I know people who lived in the same house for 40 years. They don't know where, if it, they don't understand what we're talking about, for one thing. So good question, Joan. But yeah, so you need to make sure that, and remember, you can also go online and find it. It's just something that you don't want to be. I would recommend against doing that, only because then you become the owner of the information. So you want to be the source of the source, not the source, right? You don't want to be the source of information. You want to direct them to the source of information. In my example a minute ago, when I was talking about Maria's question, was if I'm going down and pulling, and I've done it, I've gone down and pulled permits, got the wrong property, right? So now the buyer thinks they've got all the information and it was on another property, right? Or I go down and I don't know what a permit looks like. And because that's not my job, right? And by the way, it's not your standard of care either. If you go and do it, now you just elevated your responsibility and your liability, okay? So good question. Okay, thank you, Joan. So folks, I'm going to tell you, and you have documents that you put in front of your client that say, I know you don't know that, but you read them, and it says in the document that we're not going to pull permits, right? So I've told you before, go to your buyer representation agreement, paragraph 5 and 6, okay? Because I have my attorneys write it out in my class, my continuing ed. I have them write it out, paragraph 5 and 6. When you define your duty, you limit your liability. So we need to know what our duty is. A lot of times, a lot of people are really surprised. I didn't know we did all that, right? Well, you do more than you think you do. You've earned your money. I assure you, you work hard, okay? But I'm not going to run around being afraid for the rest of my life. I'm going to make sure that I get educated, like you're doing here today, to make sure. Rory, new construction is built to WI code, wildfire urban interface, right? And again, homes that are older than 2010. So, okay, so you do a lot more work than you think. Take a look at that buyer representation agreement, paragraph 5 and 6. I know you're all using it. In my office, we're not working with anybody without it, right? Because we need to define what our contractual relationship is with our buyer, okay? Much like we do with our seller, okay? For a buyer coming from out of state, assume they are all coming from out of state. So I mentioned it yesterday in one of the seminars that we were doing, the Amityville case. That's something else I have everybody look up in my classes. And the Amityville case, buyer was coming in from out of the area, wasn't aware of the local superstition about the property. They buy the property and they find out that it's got, critters, right? I mean, of course, the Hollywood makes a bigger deal out of it than it probably was. But it was one of those rare cases where the court unwound the deed. They said, put everybody back the way they were. Coming out of state, the entire state of California could be a high fire hazard zone, right? Yeah, my house could burn to the ground and not be in a zone, right? It just happened to be a zone as mapped by the state of California, which we really can't sue anyway. So in that case, it's advisable to add the disclosure regardless if we can verify with the NHD or not. If you've got your NHD, I think it never hurts to disclose. I don't believe you can over disclose. I think you should, I would say, fine, go ahead and do it. I'm going to show you a couple of things about that in just a second, okay? So where can I locate the information? And it's available through the local agency where the information should have been filed. And then, of course, as I said earlier, we can also get it on the internet. So, and again, direct the seller to that and have the seller make a decision whether it applies to them or not. Section number 2, required for residential properties with 1 to 4 units constructed before January 1 of 2010, right? And remember, a lot of our construction in San Diego County occurred back in 1977 and 1978. I mean, most of the coastline was built at that point. Well, the coastline was already built, but I mean, the houses on the coastline were built about that time. So interesting information in here. Home fire, I'm going to run out of time. Home fire hardening, read it. You need to read it. You need to know. And this is the part that's giving us anxiety at the San Diego Risk Management Committee. And that's whether or not, we're there to advise and counsel our client. And like Jackie Oliver said, how do we do that without giving them legal advice, essentially? Okay. So I made the comment in the meeting yesterday that, what's a soffit, right? So, and of course, somebody else sent me a thing. I know what a soffit is, right? But I had a court case just not that long ago where the buyer's agent the buyer's agent was asked by the buyer, is that stem wall okay? And the buyer's agent said, looks pretty good to me. Well, unfortunately, the stem wall was underwater, and so they didn't know what a stem wall was. They didn't want to look stupid. I don't know what a stem wall. And this is in a property that was a bayfront property in where was it? Keep thinking Malibu, but it's not Balboa. Anyway, that was ugly. It was millions of dollars. I mean, by the time I got there, they had already spent millions in attorneys. So readyforwildfire.org. There's the website. Over here, I've got boxes to check. I'm sorry, I'm not checking them. The seller's going to check them, right? Okay. I think we'll probably, when we're done with this form, we're going to probably make it so that you cannot check these, that the seller will have to do it in Glide or something like that. Okay. Everybody good? What was the thing? Do any of you know what a non-tempered glass window is? I mean, I think I know, but then, boy, if you ask me in deposition, I'm probably going to say, I'm not really, I'm going to have to leave that to an expert. Okay, things like that. All right, that's what that's all about. And then home hardening final inspection report. Sellers obtained a final inspection report that complies, that includes compliance with the requirements pursuant to 51182. Okay. Wow. All right. So is our job getting harder or is it just getting better? Okay. I think it's just getting better. All right. So page 2 is just blank. There's nothing on it. Okay. Everybody good with that? Let's go ahead and let's move on to my other form. Remember, my next form is my FHDA, and I definitely want to talk to you about this. This is it's just, I don't know. I've been doing this for 43 years, and I guess I've been doing it the right way for 43 years. I mean, so far so good, right? And I just, it just pains me to know that we still have this problem. And I teach fair housing, and it's like, it's just so sad. But some of it's really ugly. Okay, and so there have been some recent, like the Newsweek reports, things like that have come out, and it, boy, I sure don't want to be on one of those. Frankly, I hope I don't ever think that way, right? Thank you, Angela. I'm just double checking the questions here. So, so here's what this says: equal access to housing for all. This is the law. Okay, all right. Federal and state laws prohibit discrimination against identified protected classes. Remember, California has 22 protected classes. Okay, so and I mentioned it in a talk earlier today, and I'll tell it one more time, then I won't talk about it anymore. But one of the there was an attorney that was trying to buy a house from a seller, and the seller said they wouldn't sell it to them because they were an attorney. That's funny, right? Okay, so the buyer sues, right? Buyer says that I'm an attorney, I'm a protected class, and the court held that the buyer was not a protected class. And so I just thought that was pretty funny. But God knows, and it was the very last, number 22 of the protected classes in California says essentially all other, and so nice try. But that's what this paragraph explains. Potential legal liability, a lot of bad things can happen to you. Remember, it is federal. There's a federal and there's a state fair housing. Okay. Federal, very ugly. State, very ugly. By the way, you probably don't have E&O coverage for this. Okay. Because remember, it's a criminal act. All right. So people going around, oh, I got E&O. And it's like, no, you don't. You don't have E&O for this. Okay. It's a federal violation. All right. What else? Here's the classes and characteristics that we tell you about. So it's there's 20. Yeah. Any arbitrary characteristic. Wow. Okay. Talk about a bucket, right? I mean, if none of the others work, then maybe that one works. Okay. And then number 5, of course, training and supervision. We are required to have classes on these things. Realtor organizations prohibit discrimination. And you know that just a couple of days ago, we changed the code of ethics, taking effect immediately. So if you are found to be guilty of discriminating against, essentially hate speech, right? I mean, we just talked about this yesterday in our risk management meeting, and Ann Throckmorton, I love Ann, and she is just on it. I mean, I think she chaired the ethics committee at the National Association of Realtors, and we were talking about this subject. Again, you need to know what it is. Hopefully it's not happening, but remember, we're going to talk about the difference between discriminatory intent and discriminatory effect. Okay, so you might not have intended it, but it might have had the effect of it. Okay, all right. So again, check with your broker. Your broker needs to be current on this, and check with your lawyer. Who's required to comply? We are for sure. Sellers are for sure. Landlords are for sure. right? Examples of unlawful or improper housing conduct based on a protected class. So here are some of the examples. I want to call your attention to 8E III. 8E III, asking for or offering buyer personal information or support letters, aka love letters, especially with photos, as those letters may inadvertently reveal or be perceived as revealing protected status information, like, oh, now I know what color you are. And we had that happen. We had that happen where just recently, where the buyer sent in a love letter along with the picture of the family, and they were from another country, and the seller chose, it was multiple offer, of course, the seller chose another offer. Buyer comes back and sues and says, you saw my family, you discriminated against me because of my national origin, and the seller's defense was, I sold it to a buddy of mine from work for less money, and so you know what? As I said in Veronica's Veronica's deal on Wednesday, you don't want to have to defend that case. All right. So what we're doing in all of our listings, and again, talk to your broker, but in all of our listings, it says in the listing agreement, it says the seller doesn't want to receive any such letters or any personal information. They want to make an objective opinion of the transaction based on the facts of the transaction, not on anything else. And you need to maintain that separation. And then one of the things that came up was if the buyer embeds the letter in with the contract, the purchase offer, then you also need to have that language that says that the seller is going to deny that. And remember, again, you have to have those two things. You may not put those in the MLS unless you have a written instruction from the seller to do so. So make sure that that's included in your listing agreement signed by the seller. Okay. All right, I'm not going to read the rest of it. Unconscious bias. Again, I already talked to you about discriminatory intent versus discriminatory effect. You might not have attended it. It just might have had, hey, Don, oh, you're so cool. Can we use your photo? You like my flag? I love this flag. I mean, I got to tell you, I got a 25-foot flag getting put out in front of my house right now. Can we choose not to send a letter with the offer if the buyers insist in? No, you have a duty. You have an obligation to present all offers, right? And ask to present it with the offer. And so that's why I'm telling you, Angela, you're right on. I need to have that written instruction from the seller that says, I don't want to see it. Now, the problem we've been having in some places, and I'm talking about the Western US, because that was my group, and we have, in some cases, we have them bring them in. But worst, we're having the cameras inside the house, for example. Folks, use the PVOH form, okay? All right, the PVOH form. Use that form to your buyer, and part of it is explain to your buyer that there might be cameras in the house and they might be eavesdropping in on your conversations. And we've got some good lawsuits over that. But how's the seller not going to be able to say that I know who that buyer is? And I don't want to sell to that person, for some reason. Oh, they're an attorney. We already know that's going to fail. So you must have a written instruction, Angela, from the seller. Make sure that you talk to your broker, but it would have to be in the listing agreement itself in order for you to put it into the MLS. Okay. So in our office, again, I've written it. We're not putting anything. We're not going to take any such letters. And you're right. Buyer's agent has a right to present their offer in person per our rules, per most of the rules across the country. I don't have a lot of people taking advantage of it. If somebody said to me, I want to present my offer in person, I go, yeah, it's old school. It's really cool. We're going to do it. You have a right to be present for the offer, but you don't have a right to be present for discussions regarding a counteroffer. Okay. So big things to remember. It's really, really important. Donald, I keep looking at your message. That's so funny. Could I use your picture? Okay. And then here's some more about this form. If I don't get moving here, I'm going to run out of gas. Examples of positive practices, right? Fair housing resources. I know, folks, I know it's hard, right? There's a lot to do in real estate, but you have an obligation and you are a professional. And I guarantee you, when you're in court, it's up on the board, right? 10-inch letters, professional. And you're sitting there going, why didn't I just read that? Or better, you're here, right? I'm telling you what it says. Okay. So look over in here, read this stuff. This is important stuff. And I assure you my people do, because, I quiz them on it. But limited exceptions to fair housing requirements. So limited, okay? You'll see in there, you're going to have a roommate situation. You might be able to, restrict certain people from being in there, things like that. The owner can, not you. You cannot do that. You cannot make that decision. Remember, it has to be the owner's decision, okay? So that's my FHDA. That is my second of the forms. Yes, you can see them. Second of the forms that are coming out in December of this year. Okay, so anyway, we did release the FHDA. It says it right in there. And then, yeah, I showed you about the buyer interest letters. Okay, so let's take a look at my revisions. So remember, new forms, obviously you can't use the old form because there isn't one, right? You need to make sure you're using your FHDA in transactions. If you wrote an offer before we came out with it in October, then I would recommend, my non-legal advice is I would recommend incorporating it in your offer, in your transaction, okay? It was one of those publishes that we did kind of mid-year, so it's not attached to the form. The new contracts all have it, okay? It is part of the bundle. So when I did my notice of default purchase agreement webinar an hour and a half ago, I brought up the notice of default purchase agreement and it's not in there. Okay, so I'm going to be talking to the attorneys at C.A.R. I'm sure they're going to fix it, but I can tell you right now, it's in my purchase, it's in my listing, it's in my lease, it's in my lease listing, it's in commercial forms. All of the new forms all have this currently. So I would recommend to you very strongly that you make sure you incorporate that in your transaction. Okay, so that being said, and remember what we always say, we always talk about the user protection agreement. Here it is down the bottom of your screen. We always talk about the user protection agreement, but remember, it doesn't apply to you if you don't use the current forms. Okay, question, Jack. Answer at end of going back. I have in my all offer you presented to agent. Your opinion. Okay. Yeah. Let me hit that at the end. The seller can say that they don't want to see presentations from agents. That they want it all to go through the listing agent. The seller can say that. You cannot. And what we have happening a lot of times is we have an agent saying something because that's what they want to do, but they don't have a written instruction from the seller. And not only is that a violation of MLS rules, it could also be a license loser. Okay, so we want to be careful about that. All right. We have some people joining late here, and I'm really just to recap, we're not sending the webinar out anymore. Hey Mark, we're not sending the webinars out anymore. Because some people were, using them. We are sending the forms. So I'm going to send all of this stuff to you, or education will. I love our education department. They're going to send it to you. So let's talk about this. This is the easy part. This is the wind down part. So we've got that COP form. All right. Anybody remember, did I decide? No, I decided I was going to do the SFLS first. Okay. Because once I do the COP, everything else flows from that. Okay. And I'm going to show you why. That'll be an easy conversation, even though the changes to the form were significant. So let's take a look at my SFLS form. And the SFLS is another one. Yes, you can see it. Is another form that much like the Fair Housing Discrimination Advisory, is like, what took us so long to get around to this, right? Again, this is a new form coming out in December. Okay, why did it take us so long to do this? Okay, so Jack, you and I, we've had this conversation, right? Square footage, #1 litigated issue against real estate agents. Everybody follow me? Okay, if it's the #1, why? What is it that we're doing that's getting us tagged? And the reason is because if the buyer gets into the property, it's never the seller that sues, it's the buyer, right? And the buyer gets into the property and finds out the property is not as you represented it, then you're going to go for that, okay? And it's going to be you, all right? And so a lot of people refer me to paragraph 8A of the purchase agreement, which says note to buyer and seller, information contained in the MLS, flyers, marketing materials, et cetera, is you guys can't sue each other over it. That does not protect you and I. We are subject to Civil Code 1088, which says we are responsible for information that we put in flyers. But I've had so many people tell me that, well, it says right there. It's like, I know, but that's to protect the seller from the buyer. It's not to protect us from who? The buyer, right? And so I've told you since the beginning of days, don't put square footage on anything. The MLS requires it, okay? Take it from the tax record. Don't change it unless you are prepared to defend it. Okay, but now we have this advisory. I'm going to tell you I still wouldn't do it, but I'm telling you that this is important. This will be in our template that we create, that we use in all of our transactions. Again, 1220. Okay, so different sources of square footage. So most of you would agree with me here today. I mean, we have quite a few professionals in here today. Most of you would agree with me today that you know, people buy houses based on square footage, right? I mean, a 4-bedroom, excuse me, a 2,000 square foot 4-bedroom is very different than a 2,000 square foot 2-bedroom, right? I mean, we all know that, you know, that's a big deal. Or if the house is, you know, I sold a house in Del Mar. Tax record showed 800 square feet. You know, I go out to the property, it's 4,000 square feet all day long, right? I mean, there's just no, this is not an 800. So the county had just never updated the record to indicate the new square footage. So when I put that into the MLS, I changed it from 800 square feet to 4,200. We'd had all these people go out there and measure it, but I quoted who measured it, right? And that's essentially the bottom line behind this. So as most of you know, I can get 5 different people, much like a pest report, right? I can get 5 different people to come out, get 5 different results, right? And so, and I'm okay having 5 different results, but I'm going to quote every one of them, okay? If you take it from the tax roll, only check the very first box, public record. Public record is probably what I would check. It also gives you the option of assessor's record. I don't know what they're differentiating between, but again, you're right, absolutely, Joan. When I put it in the MLS, I'm going to be the source of the source, not the source. I'm going to check the box that says this is what the county says. But now remember, in my scenario where it was 800 square feet in the tax record and I know it's over 4,000, I'm going to quote the appraiser. I'm going to quote the seller, okay? And in fact, if I'm quoting the seller, I'm going to probably make additional comments in the confidential remarks. If the listing side, question from Angela, if the listing side doesn't provide this form, should we generate it with tax rolls information or so? So here's the thing. So if the listing, so let's take a look at the form. Who signs the form? So the form is signed by the seller, and the form is then also signed by the buyer. And notice all the caveats and all the where to for our thousand, all the legal stuff that, you know, I love seeing this. And then I watch agents copy it and put it on other things. Like, you can't do that. So they do. It's like, I probably wouldn't. But again, I probably wouldn't be putting square footage except in the MLS. But all this property size, I had a court case where the buyer says to the listing agent, says, how far back does the property go? And the listing agent says it goes back there to that fence. And so guess what? Fence people are not surveyors. And in fact, there were 2 other lots before you got to the fence. So here the buyer's thinking, I'm getting this great big piece of land. I don't care. It says it's, you know, it's only 50 by 100. And, you know, I'm looking at, that's the biggest 50 by 100 I've ever seen. The buyer, of course, buys the property and finds out, no, I've got a neighbor, 2 other neighbors that are taking up 2 more thirds of that whole lot. And that's where the lawsuit comes from. So we want to watch out for that. We don't want to get involved in those kinds of conversations. You see how that's a problem in paragraph number 2. We don't do boundaries. You know, don't tell people when they say, how far does the property go? Don't say it goes to the fence, because the fence is probably not an accurate representation. Hey, I got a ranch, right? And I've got one of my properties. I have a ranch, and I have a fence. And I, you know, it looks like, wow, it looks like it's a couple of acres, right? It's like 100 acres, you know, but the fence is not the property boundary. It actually goes farther back than that. And I'm also responsible for that part of the property, even though it's not within my fence line. Okay, so you see what I'm saying? Issues all the way around all this. So even if no numbers are asserted, the rest of this form may still be used as an advisory. We just added that language to this form just in the last couple of weeks, okay? So again, please don't use these forms until we release them for you. But that's kind of what we're looking at here right now. So in zip forms, you'd be able to fill these parts out, be able to put in the square footage. Here's the source, put in the square footage. So whose question am I answering on that? Angela. So the listing site doesn't provide it. Oh yeah, should you provide it? Yeah, I probably would. I don't care that the seller signs it first. I'm still going to provide it. Okay. So anyway, you know, whatever the source is, but how can you know what the source that the seller quoted, right? So did the seller quote the county record, or did the agent quote the county record? I mean, how are you going to know who that is unless you find out? You ask the question, or send it to the buyer, send it to the seller's agent and ask them to complete it. You can do that too. Okay. All right. So if checked, report attached, et cetera, et cetera. If the seller, remember what I said, seller's going to be problematic for me. If the seller is the one making the disclosure, then measurement comes from the following source. So the seller says, of course, what's the seller usually going to say, right? Do you think the seller's number is going to be lower or higher than other people's numbers? Think about it, okay? Probably higher, right? Because I've got more square footage, and that supposedly means my property is worth more money, especially if I'm doing it dollars per foot. And so, now everybody's going to get crazy if it turns out that the numbers aren't that way. So even if the seller makes the quote for square footage or lot size, we want to ask the seller where did that information coming from. So Angela, your question is a really good one. If I'm the buyer's agent and a seller's agent has not provided the form, then I'm going to want them to give us that information here. Okay, good question, Angela. Good question. Thank you. That's very kind of you. Okay, all right. So I know you all can't see the questions. When you type in a question in the Q&A field, I'm able to see them, but it doesn't interfere with your view of the form, and then I'm able to answer it. But I won't give complete names. I just give first names. So don't be shy. Okay. So again, brokers and agents, I love this. When we create our forms, we have so many representations that try to protect me as the real estate agent, but we never read them. And then we go and we say something that contradicts the very language that was meant to protect us, right? Remember, like my example about pulling permits, okay? Broker and agents do not have expertise in determining the exact square footage and lot size. I don't know anything. I tell you when I'm talking about my, getting the listing, that, I bring a tape measure. I'm old, right? I bring a tape measure and I always hold 0, right? And I always have the seller hold, what do I call it? The business end. And they go, why do you call that the business end? I say, because that's the part we get sued on, right? They go, you're kidding. I go, no, yeah, that's why I've never, ever in my career held anything other than 0. I always want the seller holding the business end. So they're really careful about what number they give me to put in the MLS, because the MLS requires room dimensions. Okay. All right. Okay. I'm not going to read the rest of that to you. Let's go to the next form. My RC. So this is my square footage and lot size disclosure advisory. Let's take a look at our rent cap and just cause addendum. So as you know, effective the 1st of January of this year, so 2020, we now have rent control in the state of California. So the governor at the time issued this thing that said that we're going to have rent caps and just cause. So what were the changes? Notice here, 2012 and 2020, okay? So what are the changes? I've got my recitals up front. I get down into here. Now let me show you. It is almost all red. So when you look at that, you go, God, they made all those changes. The fact of the matter is they didn't really. What they really did was just reorganize the paragraphs. And we're going to see that when we take a look at the COP form in a second. So they've really taken the part that was the most important part for us, that was at the very end of the form, and brought it up to the front of the form. So here are the bold print language about rents being increased and stuff like that. Exemptions that used to be at the bottom is now at the top. Here's the one little box that, that kind of the general idea is most people think that they're exempt. And if the owner thinks that they're exempt, then the owner checks the box, right? Okay. And so in most cases, that is going to be what's going to happen currently. But we all know that that was just the camel under the tent. I don't even know what the saying is, the foot in the door. Okay. For stuff that's going to come later, and we'll continue to lobby against some things. And so just be aware of that and watch what we do. Okay, that kind of thing. We're here to protect you. So additional exemptions only apply to just cause evictions. And again, we just move this around from another place. What are the requirements? If you're really concerned about it, read the form. Read the form, please. There's a lot of really good stuff in there. What does constitute just cause? You can still evict a tenant if the tenant's at fault, right? But again, it's a little tricky. So, I'm saying that that's not legal advice, and I'm saying you should also not give legal advice. Ask your client to read the form. And those of you who've had me as your instructor in colleges, you know that I've always said, I don't know what it says. Let's read it together. Right. And then when we read it together, they'll usually come up and say, well, it sounds like it says this. And I'll say, I can't really tell you, but it sounds good to me. I don't know. Right. Okay. So anyway, that's my rent. That's my rent cap and just cause addendum, which was the form that we came out with back in, God, I remember when we did remember we were down at the Spectrum, and we did, and Robert Sunderland was there, who, again, I think he's just a brilliant real estate attorney. And then we had Bill Jones down there as well. Wow, full house. We didn't think we were going to get that many people, but when we first started, because the law was getting ready to change, and when we first put out for it, we figured, hey, I get 30 people. We had within an hour, I think 100, and then we had so many, we had to change the location. After that, they just kept coming. We ended up doing it a couple of times. So it's big. Remember, you and I, if you're doing property management, that's a whole nother world, right? But if you're doing leases, this stuff still applies to us. So this applies to us on both. So be careful what you're telling your client. Make sure you're talking to your broker about that. So that being said, let's go into one of my favorite changes, other than obviously the ones where that we've discussed so far. Let's take a look at my COP form. So if I tell you anyone other than the purchase agreement and the TDS, any one form that gets me more phone calls from people, I just got an offer and it's got the contingency for sale of buyer's property form, and I just realized I really don't know what it says. So remember what I always say, the time to read the form is not when you're sitting in front of the client, right? Because when you're sitting in front of the client, you should already kind of have a pretty good idea of it. When I say, oh, I don't know, let's read it together, I know, right? I mean, and my client knows that I know, but they also know that I'm guiding them through the process. Some people think it's called leading the witness, but I'm guiding them through the process to make sure that they do understand it and that they have read it. Remember my FHDA, that they have read it, okay, all right, and agreed to comply. Okay, so here's my form. Again, after remember my other deal here, after the form is published it'll be on the 21st of December. Why does that say 1217? Replaces the 1217 form. You may not use the old form anymore, okay? So make sure you're using the current form, all right? So let's take a look at the COP form. Again, one of my favorites. You remember that the old one, paragraph number 8, created so much consternation for people. I just thought, oh my God, what does that mean? Did they get, I hear people call it 3-day kick-out clause, all kinds of crazy words for it. And yet nobody knew what box to check, right? So remember, when you're representing the buyer, you might fill the form out differently than the listing that the seller's agent might want. But you're representing your buyer, so you need to know what the form says. Okay. So that being said, I got my recitals up the top again. And then I've got information about the buyer's property now, the property that they have to sell to buy. Remember, that's the whole point behind the form. Buyer has to sell to buy. And so it's going to be contingency of the contract. And then it's going to have some different implications when we get into how we put it in the MLS, the sale into the MLS as well. Okay. So that being said, we have reordered the paragraphs. So lots of red again here, but we've reordered the paragraphs, and that's what's caused the red. Okay. And then, as I told you earlier, these next two forms are they've only been changed because of the COP form. And so we'll see what those changes are. It's only going to take us a minute to talk about that. And then finally, I'm going to want to talk to you about that TDS, and I'm still seeing it filled out incorrectly. And so here we go. Paragraph number 1, buyer property contingency. Okay, remember what I've always told you. Buyer entering a contract for sale of and closing escrow on the buyer's property, or only entering into a contract for sale for the buyer's property, or only close of escrow of the buyer's property. Property is already in escrow with so-and-so, okay, and the contract information for that sale, here it is, will be delivered to the seller within 2 days or however many days you fill it out. Paragraph number 2, buyer entering into contract for sale of buyer's property. And this is going to say, and by the way, we're still working on revisions to this because I'm already seeing some confusing language in here. Buyer entering a contract for sale of the buyer's property. Buyer has 17 days to enter into a contract. So that was remember that was 8B. Remember 8B in the old contract. By the earlier of the time specified when, within 2 days after the buyer enters into it, they have to give the seller notice, right? Buyer delivers escrow evidence to the seller and to escrow holder. So they provide the seller and the escrow holder the contract, the escrow instruction. Remember, you are the escrow instruction, right? Your purchase agreement is residential purchase agreement and joint escrow instructions versus the old form that said and receipt for deposit. Okay, so you are the escrow instruction, and what escrow does is escrow is just this party that's going to take care of being the neutral third thing, hold on the money, does all that kind of stuff, and they will normally issue a general provision. They may also issue something that says, we think we understand your contract to say this, right? Because in the old days, what we would do is we would send the purchase agreement after everybody had signed it over to the escrow company, and they would redraft the whole thing. And then if there was a fight between, if the escrow instruction it was inconsistent with the purchase agreement, then we had a fight, right? And it's like, who prevails? I know who prevails. The problem is we don't. So, that's because we were ambiguous about what we did, or we didn't reread the escrow instruction. So we just decided, we're going to take ownership of that. We're going to be the escrow instruction. You guys can take care of all the other stuff. Okay. So that being said, that's number two. Number three, listing and MLS status of the buyer's property. Okay, so buyers signed a listing agreement for their property. Remember that the weakest of all positions for the buyer in this scenario is that they haven't even signed a listing agreement with anybody. So that's the weakest. Then the next stronger one is that they've signed a listing agreement and they put it in they've signed the listing agreement with such and such real estate brokerage. But oh, wait a minute, is it or will it not be in the MLS? First of all, we're going to assume it's going to be in the MLS, right? Because the clear cooperation says that, right? But is it going to be in an MLS where the property is located? So we have this happening a lot, right? Where you're a member of San Diego, but you take a listing in San Francisco and you put it in the San Diego MLS, kind of with the idea being that the agents from San Francisco won't see it, so you're more likely to get both sides of the deal. You've complied with the rule, but you didn't bother to tell everybody that, oh, by the way, I'm going to put it in MLS other than the one where it is. And I know we take listings in San Francisco just the other way around. We take listings in San Francisco. That means I got to join the San Francisco Association in order to get San Francisco MLS. And that's what their requirement. It's very expensive. San Diego's just got the best deal, right? But here we are. We'll take a listing up there. We'll put it in the MLS up there, but then we'll also put it in the MLS down here. So our listing agreement will say, yeah, it's going to be in the San Francisco MLS, which is where the property is, but we're also going to put it down here because the marketing is better, right? We have really good marketing here. And I say that, and I have a lot of really, really good friends in San Francisco that there's some amazing, David Perry, this guy is like brilliant off the top, right? In fact, he and I worked together on the zip forms and all that stuff. So really bright guy. So that's the purpose behind all that. Buyer shall deliver to seller evidence of both the property listing, right? That's default language. So it's going to go in the MLS, right? Because what's the point if you don't, right? Remember, the weakest position was there's no listing agreement. And then you get a little bit better when you got it, a listing agreement with a brokerage. Here's the name of the brokerage. Okay. And then here is, it's going to be in the MLS, whether it's in the location where it is or not, right? Okay. Within 1 day after listing with the real estate brokerage. So remember, most of your MLS model rules say within 48 hours of all the necessary signatures, right? And so in this case, and I am the rules chair, so I should know, it's got to go in there, right? It's got to go into the MLS within 48 hours. And so here we're going to restrict that. We're going to make it 24 hours. We're going to make it 1 day. Okay. All right, Donald, I hope you're still with me. Close of escrow of the buyer's property. If 1A or 1C applies, buyer has until the following time to close escrow on the sale of the property. The scheduled closing of the seller's property, so kind of simultaneous close, or no later than 5 days prior to the scheduled close of the seller's property. I just realized I have another question in here. Jack, do you have to get buyer's permission to show RPA to seller of up-leg property to comply with the COP? And the answer is that the permission is going to be built into this form. And so if it's requested, yeah, you do. And we have a duty to cooperate as well. We might add language to that effect. That's a good point. And frankly, if I've put a transaction together, do I want the listing agent of the one that I'm doing having all the contact information for the people that I've sold their house? I mean, that's a really good question. Okay. All right. So where was I? I'm sorry. Status of the sale of the buyer's property. So the buyer agrees to keep the seller updated on what's going on, if there's any modification, anything like that. Now, we really didn't have that kind of language before. I'm glad we do have that now, because people were just, it's the Wild West out there, right? They're doing all these crazy things and nobody was telling anybody what was going on. You have an obligation, and you really do. I think you have a duty to maintain communication with the other party. I mean, communication's a big deal. I just had a transaction go supernova on me because the other agent just wasn't, connecting. I mean, the communication was very bad. We'd send an email, 5 days later, we'd hear back from went into my spam folder. If I hear that one more time, check your spam folder, folks, every day. If you're using free email, chances are pretty good that they update their stuff. I mean, I send out my newsletter. People say, I didn't get your newsletter. And I go, did you check your spam folder? They go, oh, here it is. And it's because Google updates their security settings on Gmail every week. And so, I'm sorry, you made me a safe sender. It's going out on Friday or Saturday. You made me a safe sender. They unmade me a safe sender, when you got it. So make sure you're double checking all that stuff. Within 2 or how many days after seller written request, but no earlier than the applicable time period to remove the contingency, buyer shall deliver to the seller evidence of the removal of those identified contingencies. Okay. So we want you to stay current. We want you to stay constant as well. Okay. Cancellation of the buyer's property. If the buyer property is in or enters escrow and either party of that escrow cancels, the buyer has 2 days to let the seller know about that cancellation. And frankly, we're going to probably update that language, because does the seller now have a right to cancel the transaction with the buyer, right? Does it just continue on? Because it's really essentially it's a new contract at that point, I think. Backup offers and seller's right to require buyer to remove contingencies or cancel. And then this goes through all that. Seller has a right to continue to offer the property for backup offers. And depending on the MLS, that you may be able to keep it inactive with having the appropriate language in the confidential remarks, that kind of thing. But it's going to depend. Check with your MLS. Parties acknowledge brokers shall not violate MLS rules. How many times are you going to have it where the seller says, I know you guys may have rules, but this is what I want you to do. Well, that might be interference with contract. I don't know. But at the end of the day, you have a contract with the MLS. So your contract says you will follow the MLS rules, and your contract with the seller can't cause you to violate your contract with the MLS. And so you're going to get a ticket. I wouldn't probably do that. Removal of buyer's contingencies and proof of funds, and this goes through all that. Most times when the buyer has to sell to buy, the proof of funds comes from the sale of the home. If I was the listing agent, I'd probably be running an RPR or doing a CMA or something to make sure that the property was listed at the appropriate price. Okay. Within a specified time period, seller shall have the right to give the buyer written notice in writing. And this is the part that confuses a lot of people. But if buyer fails to complete these actions within 2 days after delivery of such notice, seller may then immediately cancel the agreement in writing. Now, remember, the seller can cancel, and I know I've just done it. I did it a couple of days ago. Seller canceled. Seller says we're exercising our right to cancel. You didn't perform per the contract. You were given notices to buyer to perform. You didn't respond to it, and so we're canceling. And the answer is we're canceled. And so when I got pushback from the other agent, I recommended to the other agent they contact their broker and talk to their broker about it. And I guess I was right. So I know I was right. So time to give notice to remove contingencies. Seller shall have the right to invoke the notice provisions in 7B. That's above here. Okay. A, immediately. B, no sooner than 17 days after they accept. In other words, the buyer's can sit in there for 17 days doing what they got to do, and the seller can't kick them loose until then, or they don't have any right at all to kick the buyer loose based on the contingencies. And so if you're the buyer's agent, you might be looking at 7C3, which was the old 8B, right? So 7C3, because we don't want the seller to be able to kick us loose, but the seller's agent might say, well, yeah, you know what, we do want to be able to kick you loose in case you haven't sold your house yet. We need to, we have another buyer for the property. That's always the case, right? They always have a buyer for the property, somebody else. Okay. So that being said, make sure I covered it. Anybody have any questions about that? Because that's kind of an important thing. Seller's right to cancel. Seller may cancel the agreement in writing as follows: after first giving the buyer notice to remove buyer contingencies and provide proof of funds. So let's scroll down a little bit and take a look. It's going to be down here. See at the bottom of the page. Remember, this used to be the old seller's removal of contingencies, and we decided to bifurcate the two forms and make it all about this buyer on the COP, okay, rather than trying to save paper. We don't save paper anymore. We have the Paperwork Reduction Act, but now most all of everything that we do is all on the internet, okay? So after first giving the buyer an NBP, if the buyer fails to enter a contract for sale, these are all the conditions that will constitute the seller's right to cancel, okay? So I won't read them all individually. It's going to be a choice for you to do that. I'm hurrying it along because I know I've got an hour and 15 minutes and I've got 9 minutes left, and that's about what we're going to need. I've got a really important point. I hope you won't leave. I got a really important point for you here in a minute. Buyer's right to cancel. So now the buyer has a right to get out of the deal too. Time for performance of the contract. So this is the old part that said, do you want the time periods to begin now, or do you want them, at the time of the contract, or do you want them to begin as soon as the buyer is able to move forward based on their contingency? Okay, so so if you leave it alone, what does it say? Time periods of contract other obligations shall be specified as in the agreement. So if you come forward with the contract and you don't check this box, then time periods begin today, even though you might not have an offer on the other property, okay? Or on the day after buyer delivers to seller any of the following evidence of a sale, essentially, okay? So same thing we had before, just in a different place. Down here, the deposit. You want the buyer to bring in the deposit right now or 3 days after they go under contract in their home, okay? So again, that's going to be a conversation you're going to have with your seller and with your broker, and you need to have that, okay? I like everybody starting now. Yeah, I understand it costs money to do all those things, but I think you need to be prepared. I mean, I've accepted an offer, based on the fact that you're sincere about selling your home. Is the right of seller to cancel on COP Section 8 if only one of those conditions is met, or if all are met? Seems like it should say or. That's a good question. Seller's right to cancel in writing as follows. You're right. We didn't do an or. You are so right. I love it. Okay. Remember, these forms are, thank you, Dave. These forms are dynamic, and every class I teach, I find something in a form that's like, oh, wow. So Dave, I'm going to give you credit for finding that. Okay. But should be an or statement, right? And I know that this form is still being reviewed. I mean, we're still going through this. This is deep. Okay. So now that you know what you know about all the stuff about, wow, that COP form, that's changed pretty radically. Okay. A lot of the same stuff. So I'm not afraid of it, but I probably want to read it again just to make sure. And I clearly want to read it if I get an offer on it. And if I'm representing a buyer who's got to sell their house, I'd probably want to read it before I produce it for the buyer for signature, because your buyer is going to ask you questions about stuff. And guess what? You have the ability to explain standard forms, and this will be a standard form on the 21st of December, and you have the ability to do that. But guess what? You also have an obligation to explain it properly. Okay, so if you haven't read it, it's going to be really hard to explain it. I encounter that all the time when we start talking about liquidated damages and agents. I teach this in my continuing ed for attorneys class, and I ask, does anybody here know what liquidated damages means? And they go, yeah. And I go, okay, explain it to me. Nobody knows, right? They're counting on going back to the contract, to the paragraph that says, here's what it is. It's like, well, okay, but you told me you knew what it was. So what is it? Well, then they start reading the paragraph out loud because I've got it up on the board in 10-inch font. And I go, yeah, but what does it say? And so liquidated damages is, again, one of those things where if I'm sitting in court, I want to make sure that I knew it before I got here to court, okay? So read the liquidated damages provision. It's simple. Read it. It has to be written. All of our forms must be written in plain English, right? It's called the plain English doctrine, okay? They must be written in plain English if we intend to enforce them against people, okay? All right. Let's take a look at my, so I told you earlier, my COP, everything's going to flow from the COP. I'm going to take a look at my NBP, and sure enough, look at this, new revision to the NBP. Why? COP. You follow me? So here's all of the changes that occurred. Most of the changes to the notice to buyer to perform occurred because of the changes to the COP. Of course, we have some RCSD, RCSA, which we're going to have to change that because it's supposed to be D and evidence of authority to act kind of thing. Okay, so most of the changes are going to be based on the changes to the COP. Okay, take a look at my contingency removal form. Just like you would expect, same rule applies. Okay, I've got some changes to my contingency removal form, most of which are based on the COP. This one refers to C.A.R. forms in the RPA, but down here, COP. Okay, you follow me? So here's why I like you to have the red line version, because now you know you don't have to memorize the whole form. You know, you should know what it says. You should have read it at some point, right? That's kind of your job. Okay. Okay, but at the same time, I realized that this is going to be the same form that I've been using, except for these two paragraphs. Okay, and since I've already told you that it all stems from changes to the COP, look at all the red, right? Okay, that's a hint. Okay, I try to make this easy on everybody because I don't think our business is really that hard, but I think we do have some basics that we've got to do. Okay, all right, and I want you to do well. And how many times do I tell you that if you look good, you make me look good? So I want you to look good. Okay, I really do. All right, so let's take a look at one pet peeve I have that's left, and that is my well, first of all, questions. Anybody have any questions about any of that? And then I'm going to launch into the TDS, and then we're going to go to lunch or something. Okay. So here's my substituted disclosures of the TDS. So the TDS was actually revised about 1.5 years ago. We didn't catch it. C.A.R. finally updated the TDS and zip forms in June of 20. Okay, so June of this year, they actually updated the, because remember, the TDS is created by the legislators, and the legislators do what? They create statutes, okay, laws, all right, and the TDS is right in the law. You can pull up California Civil Code 1102.3, and you're going to be looking at the TDS. All we did at C.A.R. is we took the TDS and we put our stamp on it. Right? We took it right out of the statute. We said, here it is. We're going to put it on paper, and then boom, we're going to put our our logo. See our logo? We're going to put our logo on it so that it becomes us. It becomes a standard form. Well, it has to be word for word. So that when I tell you we take a picture and we put it on this, that's what it is. We took a picture. Okay. Well, the picture changed. So the legislators, who again, they're legislators, they don't do real estate, right? Necessarily. Bill Jones does. I mentioned him earlier. He's a super guy. I like him a lot. They put together, he's probably the only real estate agent in the whole group, but they put together the form, this TDS that we're now required to follow. Okay. And the TDS is, the reason why we have a seller property questionnaire is because the TDS can be really confusing. And so the SPQ asks questions that the TDS doesn't. So we kind of think that the TDS is a nice start. The SPQ is a good way to kind of break it, unpeel the onion, make it so that it makes more sense. And then we have San Diego, standard of practice, standard of care. We have the SPQA, Seller Property Questionnaire Addendum. Okay, so it's an addendum. So again, think in your head, TDS, SPQ, SPQA. I've had people say the SPQA, I don't need it. We've already got the SPQ. Yes, you do need it. You need it in San Diego County. The SPQ was taken from our risk management form called SAD, the seller's additional disclosure, and C.A.R. put their stamp on it after they made some changes to it, thinking we wouldn't notice. Fine. Okay, they created the SPQ, but they created a statewide form, and we need something that covers the local issues, and that's why we created the SPQA. So those three forms, TDS, SPQ, SPQA, and then, oh, by the way, the AVID. Okay, make sure you're using the current version of that. So when they changed the TDS, page 1, biggest change, right on page 1, used to have 2 boxes to check for substituted disclosures. Now there are 3. We didn't have the part before that says there are no substituted disclosures. We only have the other 2 conditions. This quick guide explains it really well. Good luck finding it. That's why I'm going to give that to you today. It'll make it easier for you to read it. But it explains those changes. Remember that you don't want to be found in violation of the TDS by not checking one of the boxes. You must check one of those 3, much like paragraph number C, right on page 2. I've had people send it back with boxes that aren't checked. It's incomplete. I'm sorry, it's not legal advice, but I think that's called a defective TDS. I think that's on the state exam, folks, right? A defective TDS, buyer has 2 years to sue on a defective TDS. So I'm not going to run foul of that. So this is a really good advisory on it. I think there are a couple things in there that I think that should be updated, but we added no substitute disclosures for this transfer. Folks, please make sure you're using the TDS. It is statutory. The buyer may not waive it. The seller may not waive it. NHD, same thing. It's statutory. Remember, the TDS is 1102.3, NHD is 1103.7. I'm sorry, it's the law. And there's certain parts of the law that the Department of Real Estate really thinks that we need to be following. So that's one of them. Okay, thank you all for being here. Have a wonderful weekend.
Need more help? Contact SDAR Member Services at 858-715-8040 or membership@sdar.com.